On January 11, 2026, in the 252nd District Court of Jefferson County, Texas, Judge Raquel West presided over the sentencing hearing for Ray Anthony Noe. The defendant had previously entered an open plea of guilty to two serious charges: intoxication manslaughter and driving while intoxicated with a child passenger under 15 years old. The charges stemmed from a December 11, 2024 crash on Highway 93 near Hillard Brand Road in Beaumont, where Noe's vehicle flipped after causing a collision, resulting in one fatality and endangering his own 9-year-old son, who was found unrestrained in the vehicle.
This is cause numbers 25 DCCR 0386 and 0387 on Ray Noe. Could I just, Mr. Franklin, Mr. Noe?
Good morning, Your Honor.
Right, sir, you're Ray Noe.
Yes, ma'am. Good morning, Your Honor. I'm Ray Noe.
Usually it's the other way.
Yeah, that's what I was thinking over here.
All right, and so Mr. Noe was previously in court in cause numbers 25 DCCR 0386 and 0387, entered pleas of guilty to intoxication manslaughter, as well as driving while intoxicated with a child less than 15 years old. That was an open plea to the court. We had gotten started a little bit on this hearing, and then I reset it so that the state could, or anybody could, bring any witnesses with regard to statements in the PSI and sentencing. We've all had an opportunity, correct, to review the PSI.
State has, yes, Your Honor.
Other than what we've already discussed and what the defense has filed with regard to response and objections, anything else with regard to the pre-sentence report?
Not from the state. Not at this time, Your Honor.
Okay. Obviously, with regard, well, when we get to after witnesses, we'll go through the pre-sentence, what the specific objections are. I think primarily the big part of it was witness statements outside of court. And so we'll hear what we hear today, and then we'll go through any prior criminal history that I feel like is important and admissible, and we'll talk about all that at that point. Is everyone ready to proceed?
State's ready, yes. Yes, Your Honor, we're ready.
And I will take judicial notice of the court's file. It does include, obviously, the pre-sentence report. It includes the defense response and objections to that, as well as the state's sentencing memorandum as well. And is that it? I think that was filed. There was also a letter from Joyce Barnes, the mother of the defendant, and I have that as well.
Your Honor, I think we had also previously filed letters of support, which the court had reviewed. We did not refile them.
That's
for purposes of sentencing.
Sure. Okay. If you'll take a look in the file and make sure. I feel like I've seen them all, but I don't have them printed out. If you'll just check and see if they're where they are. Okay, Mr. Coleman, go ahead. You have a witness.
The state calls Chief Angel Campos.
The court begins its sentencing hearing by establishing the procedural framework and confirming that all parties have reviewed the pre-sentence investigation PSI report. The judge takes judicial notice of the court file, which includes defense objections, state sentencing recommendations, and character letters from both the defendant's mother and other supporters. Under Article 42.12 of the Texas Code of Criminal Procedure, sentencing hearings in felony cases must be conducted with consideration of a pre-sentence investigation report, which provides the court with comprehensive information about the defendant's background, criminal history, and the circumstances of the offense. The Texas Court of Criminal Appeals in Graham v. State, 2000, emphasized that trial courts have broad discretion in sentencing matters, including the authority to consider victim impact statements, character evidence, and any other relevant information that assists in determining an appropriate punishment within the statutory range. Additionally, Texas Rule of Evidence 201 permits courts to take judicial notice of adjudicative facts that are not subject to reasonable dispute, including the contents of their own files and records from prior proceedings in the same case. Here, Judge West is carefully building the record before hearing testimony, ensuring due process by allowing both sides to present relevant evidence. The defense's objections to the PSI, particularly regarding witness statements outside of court, signal potential confrontation clause issues under the Sixth Amendment, as the defendant has a right to challenge evidence used against him at sentencing. By resetting the hearing specifically to allow witness testimony, the court is creating an opportunity for the defense to cross-examine adverse witnesses rather than relying solely on hearsay statements in the written report. The careful procedural groundwork laid at the beginning of this hearing demonstrates how sentencing is not merely a ministerial function, but a critical stage of criminal proceedings where constitutional protections remain fully applicable. Courts that rush through sentencing without adequate notice and opportunity to be heard risk reversal on appeal, as the Texas Court of Criminal Appeals held in Garcia v. State, 1994, where failure to allow meaningful participation in the sentencing process violated due process guarantees.
Trooper Campos, good morning, sir.
Morning.
You'll please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You can have a seat.
Please state your full name for the court reporter, please.
Angel Campos.
And
Can you pull that microphone a little closer?
Closer?
Yeah, thank you.
Trooper Campos, how are you employed, sir?
I'm employed to the Texas Department of Public Safety.
And how long have you been with DPS?
I've been with DPS today almost 3 years.
Okay, and certified peace officer, correct?
Yes,
And your training and background, of course, includes the academy. I understand you also have some military background as well. What does that include?
I do. I'm working on my 11th year serving in the Marine Corps, and currently I'm a Staff Sergeant E6 in the Marine Corps today.
Okay, I'd like to take you back to December the 11th of 2024. Were you working that day?
I was.
At around 7:56 or so, were you dispatched to a crash?
I don't remember the exact time, but roughly around that time, yes.
Did you bring a copy of your report? with you?
I do not know. I left my laptop with the.
Is it on your laptop?
It's on my laptop.
John, can we retrieve that laptop? I'm sure he's gonna probably.
Sure.
The prosecution calls its first witness, Trooper Angel Campos of the Texas Department of Public Safety, who is sworn in and begins testifying about his response to the December 11, 2024 crash. The trooper establishes his credentials as both a peace officer and a Marine Corps Staff Sergeant with 11 years of service. Under Texas Code of Criminal Procedure, Article 38.05, peace officers are competent witnesses in criminal proceedings, and their testimony carries particular weight in intoxication cases where specialized training in standardized field sobriety testing and DWI detection is relevant. The Texas Court of Criminal Appeals in Hawkins v. State 2015 held that officers may testify about their observations of intoxication based on their training and experience, provided they do not improperly opine on the ultimate issue of guilt unless qualified as expert witnesses. Additionally, under the Texas Rules of Evidence, lay witness opinion testimony is permissible under Rule 701 when it is rationally based on the witness's perception, helpful to the trier of fact, and not based on scientific, technical, or other specialized knowledge. Trooper Campos's dual background in military service and law enforcement establishes his credibility and observational training, which the prosecution will rely upon to describe the defendant's demeanor and conduct at the crash scene. The defense's earlier objection regarding expert opinion testimony signals their strategy to limit the trooper to factual observations rather than conclusions about the defendant's state of mind or intoxication level, distinctions that matter significantly under Hawkins and related cases. The foundation laid through witness credentialing determines what testimony the jury, or in this bench proceeding, the judge may properly consider. Courts that allow unqualified opinion testimony risk violating the defendant's confrontation rights and creating appellate issues, while overly restrictive rulings may prevent the fact finder from hearing relevant contextual information. The careful balance struck in this hearing illustrates how evidence rules shape the narrative that emerges at trial.
And if we can, do you have a hard copy, you have a copy, Mr. Franklin, I'm sure,
I have.
I do not have a copy of them.
but it was in Discovery.
Yeah, of course.
It was produced, Your Honor.
Okay.
You remember this crash, right?
I do.
And if you want, let's do this. If it's helpful for him to use his computer, that's fine, but let's get a hard copy for defense counsel. Everybody can have a hard copy. We can make copies if we need to. I'm assuming, do you want a copy? Are you okay?
Yes, Your Honor, I'll take the copy. I've got notes on all the relevant portions for myself.
Okay.
I didn't have a copy.
Okay. If you have it, fine. If not, let's do this. Why don't you just have him go ahead? He can pull it up on his computer and no, that's okay. If anybody needs a hard copy, then we can work on that at that time. You can let him work off his computer. You don't have any issue with that, do you?
No,
Okay.
I probably just for record's sake, I'll ask him.
You have it pulled up. Just let me know when you get
It's loading up.
December the 11th, 2024. Did you receive a dispatch around 7:56 or so?
Yes.
What was the nature of that dispatch?
Initially, it came out to a two-vehicle crash on Spur 93 near Hillenbaum Road.
Hillebrand Road,
Yes,
and that's in Beaumont, Texas, correct?
it is.
Jefferson County, Texas?
Yes.
All right.
After resolving logistical issues regarding the trooper's report, the witness testifies about the initial dispatch to a two-vehicle crash on Highway 93 near Hillenbrand Road in Beaumont, establishing the time, location, and nature of the incident that forms the basis of the charges. Under Texas Transportation Code Section 550101, any peace officer who investigates a motor vehicle accident resulting in injury or death must submit a written report to the Texas Department of Transportation within 10 days. These crash reports, while generally inadmissible in civil proceedings under Section 55065, are routinely used in criminal prosecutions as substantive evidence or as a refresher for officer testimony. The Texas Court of Criminal Appeals in Vickery v. State, 2011, held that officers may rely on their reports to testify about observations made during accident investigations, provided the testimony is based on personal knowledge and not impermissible hearsay. The prosecutor methodically establishes the foundational facts of the crash, date, time, location, and initial dispatch information, to create a coherent narrative for the sentencing court. By confirming these details through live testimony rather than simply admitting the report, the state ensures the evidence is properly before the court under the personal knowledge requirement of Texas Rule of Evidence 602. The defense's accommodation regarding the laptop suggests a strategic decision to avoid appearing obstructionist while preserving potential appellate issues. The meticulous documentation of accident scenes serves multiple purposes. It preserves evidence for prosecution, provides data for highway safety analysis, and creates an objective record that can be scrutinized by courts and juries. In intoxication manslaughter cases, where the defendant's mental state and physical condition at the time of the crash are often disputed, the responding officer's immediate observations frequently become the most critical evidence in establishing guilt and determining appropriate punishment.
And please, briefly, the judge will see the video here in just a second, but briefly describe for the judge what you observed when you made the scene.
Initially, when I made scene, I was expecting, like I was dispatched to two vehicles. Then I later found out the two vehicles that I rode up on, one was the deceased's vehicle, and the other one was the witness that witnessed the entire crash. I didn't see a third, but I couldn't really comprehend what had happened because I couldn't find the car that did everything. And then I later found out through on-scene personnel that the vehicle that caused the crash was further down the road, upside down.
Did you make contact with the driver or the operator of that vehicle?
I did.
And was he identified?
He was.
Who was he identified to be?
Anthony Noe.
Okay. And was the vehicle that that the defendant Anthony Noe was driving, was it also, did it have any passengers in
It did.
it? And how many, and what was their age in relationship to this?
It was his child. I want to get the age exact. I don't remember exactly. But I think he told me at the scene here that he told me he was 9 years old.
Okay. And through your investigation, did you determine if that child was restrained in that vehicle during the crash?
The investigation determined the child was not restrained at the time.
Trooper Campos describes arriving at a chaotic crash scene where he initially found only two vehicles, one containing a deceased victim and another containing a witness, before learning that the defendant's vehicle had continued down the road and flipped. The trooper confirms the defendant's identity and the presence of his unrestrained 9-year-old son in the vehicle. Under Texas Penal Code Section 49.08, intoxication manslaughter is a second-degree felony punishable by 2 to 20 years in prison when a person operates a motor vehicle while intoxicated and causes the death of another by accident or mistake. The offense is elevated to a first-degree felony under Section 49B09(b)(2) if committed while a child younger than 15 years of age is a passenger in the vehicle, reflecting the legislature's judgment that endangering children warrants enhanced punishment. Additionally, Section 49.045 creates a separate offense of DWI with a child passenger, a state jail felony, specifically targeting the dangerous conduct of driving under the influence with vulnerable children present. The trooper's testimony establishes the factual predicates for both charges. The fatal crash satisfies the elements of intoxication manslaughter, while the presence of the unrestrained 9-year-old child triggers the enhancement provision and independently supports the DWI with child passenger count. The child's lack of restraint, while not an additional criminal element, demonstrates aggravated recklessness that the court will likely consider in assessing punishment, as it shows disregard for even minimal safety precautions. The dual charges reflect Texas's comprehensive approach to deterring impaired driving, particularly when children are endangered. The enhancement structure ensures that defendants who combine intoxication with child endangerment face substantially more severe consequences, recognizing that such conduct imposes risks beyond the immediate harm to other motorists. For sentencing purposes, the unrestrained child passenger represents both a statutory aggravating factor and a compelling circumstance supporting maximum punishment within the available range.
When you made contact with this defendant, we're not going to spend a lot of time on it because he's already pleaded guilty, but nevertheless, you observed signs of intoxication, correct?
Yes,
Did he refuse or did he consent to a blood draw?
he refused.
And you obtained a blood search warrant, correct?
I did.
And his blood was drawn pursuant to that blood search warrant.
Yes.
What I'd like to ask you about next and explain to the court is this defendant's demeanor. How would you characterize this defendant's demeanor there at the scene? And
So his demeanor,
Your Honor, I'm going to object to this to the extent that he's required to asking him to opine because he has not been established as an expert on opinion that he can. I don't have an objection to him observing what his observation, but to the extent he's going to opine, we're going to redo our objections that we've already made in our response to objections.
That's overruled. He can testify as to what your opinion is as to his demeanor that evening.
please go ahead and answer truthfully.
the demeanor on that night, he refused to comply with almost every order we gave him. We had tremendous amounts of patience, try and do our job, and he made it every bit difficult, to include the omittance of, allowing us to prove. I even asked him on scene if he could let me do centralized field sobriety test so we can rule out his intoxication, and he refused that too. Try to give him a chance there, try to give him a chance to consent blood, and he refused there too. Did every trick. Well, it appeared like he was trying to buy time for himself, and he through my training and experience, we kind of pick up on tricks that DWIs do, and it appeared like he was utilizing everyone he could.
And I'm sorry to interrupt, but we're talking about more than just a refusal or more than just not cooperating, correct?
Yes.
I mean, how would you describe that to the judge?
I would object to leading on that one, Your Honor.
Overruled. Go ahead.
Everything on that night, he, from what I can recall and remember, everything he mentioned or asked, none of it was about the other parties. It was all either about himself.
The trooper testifies that the defendant refused both field sobriety testing and a consensual blood draw, necessitating a search warrant. Over defense objection, the trooper characterizes the defendant's demeanor as uncooperative and self-focused, noting that the defendant showed no concern for the other crash victims. Under Texas Transportation Code Section 724.013, a person's refusal to submit to blood alcohol testing following a DWI arrest is admissible in any criminal proceeding, and such refusal may be considered by the court as evidence of consciousness of guilt. The Texas Court of Criminal Appeals in Beeman v. State, 2016, held that officer testimony about a defendant's demeanor, attitude, and statements during investigation constitutes proper lay opinion under Rule 701 when based on personal observation and helpful to understanding the circumstances. However, the boundary between permissible lay observation and impermissible expert opinion requires careful attention, as the court emphasized in Kelly v. State, 2008, where unqualified testimony about psychological states crossed into expert territory. Judge West's ruling allowing demeanor testimony reflects the broad discretion trial courts enjoy in admitting lay opinion that assists the fact finder, particularly in bench trials where the judge serves as both evidentiary gatekeeper and ultimate decision-maker. The trooper's observations about the defendant's self-focused conduct, contrasted with absence of concern for the deceased victim, are relevant to sentencing under Texas Code of Criminal Procedure Article 37.07, which permits consideration of any matter the court deems relevant, including the defendant's character and conduct, The defendant's demeanor at the scene provides the sentencing court with critical insight into his culpability and potential for rehabilitation. Courts consistently treat post-offense conduct, including expressions of remorse or its absence, as highly relevant to punishment determination. The trooper's testimony that the defendant focused solely on himself and his son while ignoring the fatal consequences of his actions for others paints a picture of moral culpability that supports severe punishment and raises concerns about the defendant's acceptance of responsibility.
For his son.
Approach the witness, Your Honor.
Yes, sir.
I'm showing you what I am marking as State's Exhibit number 1, and I'll ask you for the record, what kind of device are we looking at?
This is a USB.
And do you recognize this USB?
I do.
How do you recognize this USB?
We reviewed this USB prior to.
We being me and you in my office, correct?
Yes,
How do you know that that's that USB?
because I initialed it and dated it today.
Is this a fair and accurate copy of your body worn camera from December the 11th of 2024?
It is.
Did it capture your interaction with this defendant on the scene and at the hospital during the blood draw? Equipment, was it properly operating as far as you know?
Yes.
At this time, State Officer States 1 has been previously provided to defense counsel in this.
We don't object in that, to the extent that it has the discovery that's been produced, true.
States 1 is admitted.
Permission to publish.
Yes, sir.
Trooper, while I'm setting this up, I mean, we've got over 3 hours with the video here. For the court's information, we'll only be pushing the same button that I always push. The switch from the Elmo to the computer, and it's just not going.
Look, there's a,
I always hit this button, and it gives me an option to switch to the HDMI. It's not even giving me for the record. Your videos, they are broken up into separate recordings, for lack of a better term, right?
Yes.
And we've got body worn camera 1.1, 1.2, 2.1, 2.2, and body worn camera part 3. All right. For the record, I'm going to go to about 20.
The prosecution offers body-worn camera footage from the trooper's device, marked as State's Exhibit 1, which is authenticated by the trooper and admitted without objection. The parties prepare to publish selected portions of over 3 hours of video recording from multiple camera segments. Under Texas Rule of Evidence 901, authentication of electronic evidence requires evidence sufficient to support a finding that the item is what the proponent claims it is, which may be established through witness testimony that the recording is a fair and accurate representation of what it purports to depict. The Texas Court of Criminal Appeals in Carmouche v. State, 2002, held that video recordings are admissible when properly authenticated and relevant, with the trial court retaining discretion to determine whether the probative value of the evidence outweighs any danger of unfair prejudice under Rule 403. For body-worn camera footage specifically, Texas Government Code Section 411.199 requires law enforcement agencies to maintain policies for activation, retention, and release of recordings, ensuring their integrity as evidence. The trooper's authentication through personal initials, date, prior review with counsel, and confirmation of proper operation satisfies the foundational requirements for admission. The defense's limited objection, confined to discovery compliance rather than authenticity or relevance, suggests strategic acceptance of the video's admissibility while preserving potential challenges to specific content. The court's admission of the exhibit permits the prosecution to present the jury, or here, the judge with direct visual evidence of the defendant's conduct and statements. Body-worn camera footage has transformed criminal litigation by providing objective documentation of police-citizen encounters that previously depended solely on conflicting witness accounts. In sentencing proceedings, such recordings offer courts unfiltered access to the defendant's demeanor, cooperation level, and statements at the time of the offense, often providing more persuasive evidence than witness summaries. The prosecution's decision to present selected excerpts rather than the full 3 hours reflects both practical constraints and strategic narrative control, ensuring the court sees the most impactful portions without unnecessary repetition.
3 minutes.
Yeah, okay. Not quite knowing. If it is, great stuff, if you, if I got, that's my recommendation here. That's the whole level. Yeah, no, I can tell you, it's fired. What's your, can I have my driver's license tonight? What's your, Sunday phone? Can I please have my expired? That is expired, that's the legal piece to have. Can I please have the last piece? Hey, what's going on, man? First ballot information. I just want to say, how did you want it to stand? What's your, son, that is like 20 years old. What's your son's information? Player science. What is the son's info? Birthday, the individuals. Okay. Things what I'm doing. That name Noe? Yeah, yes, sir. What's the first 15? 0208 2015, I think. He was sitting in the, was he sitting in the front seat there or in the back? Yeah, I know. It's in front. Front, right. Front passenger. All right, thank you. Thank you, Mayor. Sir, I'm just trying to see where they were saying. I have an information back for me. That's why he's working your crimes investigation. I know what he's doing. I don't, that's my information. And when you're trying to keep, I want to get it from you. So you want your expired driver license back? All right, ready. Here I wish you okay.
For the record, I'm gonna fast forward to about 35.
Yeah, sorry. Yeah, he's not. What's going on? My son is not just worried, just operate for you. Okay, he's not even cooperate. My son tells me. Well, he tells me you don't want him to take it off. That's not it. He's got you on something. Not put it in. Yeah, that's his problem. I talked to my son and he's saying it's okay. Nobody wants to help you. Everybody's okay. Do you want any more attention, please? I want my son to be okay. Okay, so I want my son to be okay. Let them take him to hospital. Okay, okay. He's crying. Yeah, I'm stressed. What do you gotta take him? Yeah, they said all the time. And he's alive. Yes. It isn't sorry for what he wants to be okay.
For the record, I'm fast forwarding to 52.
Go right in. You got a name? Well, it's the whole. These were. And the whole problem is, I'm confused of what points. Right. Come on down. I'm making it up. I'm phone. Put the phone down. Put the phone down. Put the phone down. Put it right there. Yeah, I have my phone right now. No, I don't need it right there. You don't know to give my thing. Let's go. Contract on the ground. I don't mind. All right. What are you guys doing right now? I'm thinking behind this. Right, stop. What's this? Stop. Right, stop. My son's in the traffic there. Why are you out of here? You don't know all about this. Why are you telling me? We're trying to help you out. You guys, I appreciate all y'all. I love my brother. No, why are you telling me like that? We're trying to help you out. No, you like you're my brother too. Why are you? We're trying to help you out here. I appreciate that, but why are you trying to? You're saying right now, we're trying to help you out here. You guys are trying to help me. No, we're not. My wife's on the phone right now. No, she's calling me. My wife's calling me. Can you please answer the phone? My wife's calling me. No. All right, we got some questions for you. You're always remote. There's two sides. You're gonna tell one you to tell your I want you to tell your side. Okay. We're gonna try and get as much help as possible. Can you please answer the phone? So you want to make response, but you don't want them to help. I just want my wife to answer the phone, dude. We get your gun out, correct? I saw you not call for your brush. It's gonna put your gun out, all right? Playing this game. You see, you've been through it before? No, I've never been through it. Now, why are you saying you know more less than us? I'm not saying I've been through it. I've been talking to you, man. You're gonna go all over this time. All right, hey, well, we're gonna get there eventually. Honestly, I don't want to get hurt. I have a, it's okay. Look, no, thanks enough for you. When you're trying to let me tell you something. I'm the same as you. We're all the same, okay? This time, okay? He's 9 years old. You know, I'm 32 years old again, and I know you guys feel a lot of power because you guys are feeling this. Are we doing our job? Oh, no, I know you're doing your job. Well, I've done my job.
Right.
And I've done my job, and I've done your job the same as you've done your job, and I've done the same as you've done your job, and I feel overpowered over a lot of people. Well, appreciate, I can find you squeezing me harder. Good, it's good. We're trying to help you out. You're not the only one doing it. So you're doing your job, and you're plus doing your bonus great stuff into this. Here, and he's gonna wait here. Where are you? I'm taking to a free chair. If he gets a frying apple, I'm not going anywhere yet. It's about me and my son, man. We're gonna get somebody here. You know, it's about you and putting your. I just wanna go home with my son. Is your wife here in the area? Yes or no? 2 years soon. I see crowds and food. It's the life is right. How long? All right, and we're gonna wait here for hours. It's probably on the road. Can I talk to somebody, please? Can I please talk to somebody, cars? I'm trying to get somebody to come pick up his son. Son is 9 years old. My wife is, she's only like, 25 years old. She'll be 25 and she's only just begun to be pregnant. Okay. Can I please have somebody who will care for me or somebody who. Somebody who's not forgetting you, man. I'm trying, okay? You're trying, I just want somebody who's all cares on you, okay? So I can't be, buddy, it's good for me. I want someone who cares about me, not somebody who's gonna throw me in the jail. And you know, we gotta wait for, I mean, I was gonna find out where the wife is at. Videos. Where were they? See all that. We'll set this back. On step at a time. They those. Give you water. You got their reasons. We're not saying, so, saying you can most definitely refuse, withdrawal of blood specimen. That is essentially, that's. I've already went to, what I'm getting at here is, do you want us to sign saying you refuse, or you don't have to, if you don't want to, that's just here. Well, that's usually I've already done that refusal. So you don't want to, so I'm not, you want to sign saying you don't, well, I'm not trying to refuse, like, I think if I'm not trying, being signing up for refuse was, I had already checked the box for that, like, I was okay, so you didn't let me saying that I could look at that or just. We're ready to, where do you want us to look at? No, I'll click right here, if you want to just sign right here saying, hey, yeah, I refuse. You don't have to, if you don't want to, still want to, I just, what do you want to refuse? Refuse, what you didn't verbally say is that it's not, I think there's stuff in here, you know, it's all, you can't sit there and wait to talk to me. So I'm just put that you refuse, I want to signature. No, I did not refuse. Okay, so what do you want to do? I did not refuse, I tried to do a lot of times, saying, you want me to refuse you? That doesn't help me. No, I was not refusing the stuff. You only first years, you're almost. And I look at that, I was not refusing, but they're not giving me an option here. It's like you want me to refuse, and I'm not trying to. You have to do other things that you need. So, it's not refuse, which still, we have a, I didn't get your, we have a, oh, okay, we have one time to judge, so. We're ready to go and get a specimen of your blood, it's whoever gets to go, which can grab that, okay? Okay, well, I did refuse. I mean, you can sign, and you're cool, it's not. No, I mean, well. Okay, we'll hurry down this round. All right, that's how we're gonna go. But I tried to talk to you even in your cruiser. If you're right. Letting you pour your bus open, you know, sorry, grab this piece. I don't know who, where the athletes get from here. We're good, though. And you should fill this out, but yeah, you're literally just like throwing me into it even now because the cruiser I told you I want to talk to you and say you must know. And you was so just from not living with here. Not care about me or I have to fail or nothing at all. It's all been about you. I just have to I like to say down, man. Like what would happen? You know, if I can research it, research what that you're read, or like what you're being charged with the case law or something.
He's asking to research, he mentioned case law.
Because I know I'm just sitting here and imagine this, so whenever I have access to one guy, I know.
Alright, you're gonna start freaking out.
I probably,
If you're wondering what
I'll ask you
the
a
liberation is, it's the felony of the second.
what is that?
And what you're being charged with.
Which is the worst number 4?
The worst is capital, but you're not there. It's the first, second, third,
and state jail. It varies depending on offenses, but just bare minimum, 2 to 20 years. Or
The court views selected portions of the body-worn camera footage showing the defendant's interactions with Trooper Campos at the crash scene. The video reveals the defendant requesting his driver's license, expressing concern about his son, and eventually stating, "I hope that everyone is okay," while appearing confused and agitated. Under Texas Rule of Evidence 1002, known as the best evidence rule, an original writing, recording, or photograph is required to prove its content unless an exception applies, but duplicates are generally admissible to the same extent as originals under Rule 1003. The Texas Court of Criminal Appeals in Vickery v. State 2011 emphasized that video evidence is particularly valuable because it allows the fact finder to observe demeanor, tone, and context that cannot be conveyed through testimony alone. In sentencing proceedings, Texas courts have broad discretion to consider virtually any relevant information, including video evidence of the defendant's conduct during and after the offense, as established in Ex parte Thomas, 1995. The video excerpts provide the sentencing judge with direct, unfiltered observation of the defendant's behavior, allowing her to assess credibility and demeanor independently of the trooper's characterization. The defendant's fragmented statements and apparent confusion, whether attributable to intoxication, trauma, or other factors, are now visible to the court, creating a more complete picture than witness testimony alone could provide. The prosecution's selective presentation, fast-forwarding between key moments, shapes the narrative, while the defense retains the right to request additional portions if helpful to their position. The admission of body-worn camera footage in sentencing hearings illustrates how technology has expanded the evidentiary basis for punishment decisions beyond traditional written reports and witness testimony. Courts can now observe defendants' actual words, physical condition, and emotional responses, enabling more individualized and informed sentencing. However, this capability also raises questions about proportionality and context, whether brief clips fairly represent complex situations, and whether visible impairment or distress should mitigate or aggravate punishment. The defendant's eventual statement hoping others were okay, however delayed or fragmented, may become a focal point for the defense's argument regarding his capacity for remorse.
In your interaction with the defendant that night, you'd already informed him that someone had died as a result of that accident. Before you informed him, and even after, did he ask or inquire of you what happened to the other individual or individuals involved in the accident?
Not that I can recall, no.
Fair to say that his focus was just on himself throughout your entire interaction with him.
Yes.
Pass the witness judge.
Thank you, Mr. Coleman. Mr. Franklin?
I have no questions for this witness, Your Honor.
All right, any objection to Trooper Campos being excused?
No, yeah.
None, Your Honor.
Thank you, sir. You're excused.
Yes, Your Honor.
State has no further witnesses in the state arrest judge.
All right, thank you. Any witnesses, Mr. Franklin?
Your Honor, I advised my client about his constitutional rights to testify or not testify. I've advised him against taking the stand. He's decided not to take the stand. I just want to make sure that we put it on the record that he has been advised and he has chosen not to take the stand, Your Honor.
The prosecution rested its case after Trooper Campos testified that the defendant never asked about the other accident victims, even after learning someone died. The defense then formally placed on record that the defendant, Jamal Noe, was exercising his Fifth Amendment right not to testify despite having already pleaded guilty. The Fifth Amendment to the United States Constitution provides that no person shall be compelled in any criminal case to be a witness against himself, a protection made applicable to state proceedings through the 14th Amendment in Malloy v. Hogan, 1964. In the 2001 case of Ohio v. Reiner, the Supreme Court reaffirmed that this privilege extends to any witness, civil or criminal, formal or informal, whenever the answer might furnish a link in the chain of evidence needed to prosecute the claimant. Texas courts have long recognized that a defendant's silence cannot be used as substantive evidence of guilt, as established in Bumper v. North Carolina, 1968, and consistently applied in state proceedings under Article I, Section 10 of the Texas Constitution. Here, defense attorney Franklin meticulously documented that Noe was advised of his right to testify, counseled against it, and made an informed decision to remain silent. This procedural safeguard prevents any appellate claim of ineffective assistance of counsel and ensures the record reflects a knowing, voluntary waiver of the right to allocution. The prosecution's emphasis on Noe's self-focused behavior during arrest, Never asking about other victims now takes on added significance, as the defendant has chosen not to explain or contextualize his conduct through testimony. The strategic decision not to testify in a sentencing hearing, even after a guilty plea, illustrates how Fifth Amendment protections operate throughout all phases of criminal proceedings. Defendants often fear cross-examination could open doors to damaging character evidence or prior bad acts. However, this silence also means the defense must rely entirely on documentary evidence and attorney argument to humanize the defendant here. Letters from his mother and evidence of post-accident sobriety without the persuasive power of personal accountability expressed in the defendant's own words.
Testify, I would like to.
And so, Mr. Noe, you have every right to testify if you would like. Obviously, you've already pled guilty, so there's not an issue with regard to, whether you did it or not. There's been a plea of guilty. If you've talked with your attorney and it's your decision not to testify, is that correct?
I just wanted to apologize, ma'am.
All right.
Um,
That's good. Thank you. If you want to testify,
but
you can get up on the stand because you'll be subject to cross-examination. So you can't just make a statement to me.
Okay.
If you want to get up on the stand,
No.
I'll swear you in and then the attorneys can question you.
no, Your Honor.
So then, I will, I guess, Mr. Franklin, you may proceed, with, argument.
Thank you, Your Honor. Would you like me to do it here or at the, it
Um,
doesn't really matter. to me,
you're fine there.
Okay.
That's wherever you're more comfortable. It's
Your
fine.
Honor, we've made our arguments and our motions and responses. I did just want to comment a little bit on the evidence from Trooper Campos.
Sure.
And point out that, some of the language used by him about the worst case, et cetera, he just testified he's been with DPS for 3 years. He would have been with them around a year at the time. What the evidence actually showed was Mr. Noe saying please and yes, sir, that he wanted his son to be okay. It was really only in the last video that he had finally learned, that he testified that Mr. Johnson had passed away in this case. There was no testimony about him having any knowledge of that in the prior videos. And the question was, at this point, did he know? And he said yes, but there was no testimony that he did know in the prior ones. And I think the evidence would reflect that as well.
Defense attorney Franklin delivered his sentencing argument, challenging the trooper's characterization of Noe's conduct and emphasizing that Noe's apparent indifference to other victims occurred before he knew anyone had died, only learning of the fatality in the final video. He also contested the prosecution's framing of Noe as belligerent and reckless. Under Texas Code of Criminal Procedure, Article 37.07, Section 3A1, at the punishment phase of a non-capital felony, the jury, or here, the judge may consider all evidence admitted at the guilt phase plus additional evidence of the defendant's character, prior criminal record, and any other evidence having probative value. The 2019 case of Blount v. State established that sentencing evidence must be viewed in context, and the 2015 decision in Villegas v. State held that courts must not draw adverse inferences from a defendant's exercise of constitutional rights. Furthermore, the Texas Court of Criminal Appeals in Smith v. State 2017 emphasized that punishment assessments require individualized consideration of mitigating circumstances, including the defendant's mental state and comprehension of events at the time of offense. Franklin's argument strategically parsed the temporal sequence of Noe's knowledge. The body cam footage showed concern for his son and compliant language, please, yes, sir, before the fatality was disclosed. Only after learning of Mr. Johnson's death did Noe's demeanor potentially shift, yet even then, the defense contests whether belligerent accurately describes behavior that included requesting legal counsel and expressing concern for family notification. This contextual framing matters because Texas Penal Code Section 49.08, intoxication manslaughter, does not require specific intent to kill, but sentencing under Section 12.42 can be substantially enhanced if the court finds the defendant's conduct exhibited extreme indifference to human life. The defense's effort to deconstruct the prosecution's narrative illustrates how sentencing hearings often become contests over character interpretation, what the 2022 Texas Judicial Commission on sentencing practices called the storytelling phase of criminal proceedings. By highlighting Noe's inexperience with law enforcement and the progressive revelation of information during detention, Franklin invites the court to distinguish between callousness and confusion, between selfishness and shock. This distinction can mean the difference between probation and years of incarceration, particularly when the defendant presents credible evidence of rehabilitation.
The other thing is, of course, the court takes into account all the evidence. Part of the statements about the reprehensible nature of my client's actions, about how he was belligerent and reckless. I'm not sure that any of the evidence produced by the state, particularly on the scale of belligerent and reckless defendants, actually rises to that level, and nor is his decision to exercise constitutional rights belligerent, irate, or reckless. And for these reasons, we ask the court to consider or not consider the statements regarding belligerent, or at least consider the evidence that was presented for what it was. And otherwise, our arguments have been in our written motion, Your Honor, and we've presented information to the court, including the letter from his mother, the letters of support, and the information about his sobriety since the accident. And for these reasons, we ask that this court put the defendant on.
Thank you, Your Honor. Likewise, I would rely on its pleading in its sentencing memorandum. Your Honor, the court's read it, so I'm not gonna belabor it. I'll just, if I could just briefly hit the high points, Your Honor. This defendant's blood alcohol was a 0.149, and he had his son, a child passenger in the vehicle, while he was driving at a 0.149, and that child, his son, who in the video he professed that he cared so much about, was not restrained by a seatbelt. Judge, we have a situation here, but for the grace of God, that his son didn't die, and that more people on the roadway that evening did not die. Judge, I think what's aggravating in this case, and I attached a copy of the safety paperwork to my sentencing memorandum, is that this defendant, as part of a probation for felony possession of marijuana back in 2013, was assessed 7 months of safety. And I would think that after 7 months of safety, he would have addressed what, if any, substance abuse issues that he may have had, that including alcohol.
The prosecutor delivered the state's sentencing argument, emphasizing aggravating factors: Noe's blood alcohol concentration of 0.149, his unrestrained 9-year-old son in the vehicle, and prior participation in a substance abuse education program following a 2013 felony marijuana conviction, suggesting missed opportunities for rehabilitation. Texas Penal Code Section 49.045 elevates DWI to a state jail felony when committed with a child passenger under 15, reflecting legislative intent to protect vulnerable occupants who cannot consent to risk. Under Section 12.42, prior felony convictions can enhance punishment ranges substantially, transforming what might be a 2 to 20-year third-degree felony into a 5 to 99-year or life first-degree felony. The SAFE fee program referenced, formerly the Substance Abuse Felony Punishment SAFP program under Texas Government Code Chapter 493, represents an intensive residential treatment alternative to incarceration that the defendant previously completed, yet apparently without lasting behavioral change regarding alcohol use. The prosecution's argument weaves together statutory aggravators to construct a pattern of persistent substance abuse despite intervention. The .49 BAC, nearly double the legal limit, demonstrates significant impairment, while the unrestrained child passenger transforms the offense from personal risk to endangerment of a dependent. Most critically, the 2013 SAFP completion suggests to the court that lenient, treatment-oriented dispositions have already been attempted and failed. Under the sentencing framework established in Young v. State 2014, Texas courts may consider the defendant's life and circumstances, including prior rehabilitative efforts, when determining whether community supervision can reasonably protect public safety. The prosecutor's emphasis on prior treatment failure addresses what criminologists call specific deterrence, whether this particular defendant can be dissuaded from future offending. When defendants complete substance abuse programs yet reoffend with alcohol-related crimes, courts face difficult questions about whether the problem is insufficient treatment, insufficient commitment, or insufficient consequence. The SAFP program's 7-month duration represents substantial state investment in rehabilitation. Its apparent ineffectiveness here may persuade the court that incapacitation through incarceration, rather than further community-based treatment, serves both punitive and protective functions. This tension between hope for redemption and protection of the public lies at the heart of sentencing discretion in intoxication offenses.
And I find that him finding himself in this situation, a more egregious situation, could have been avoided had he taken full advantage of the rehabilitative effect of safe P, Judge. Mr. Johnson, the victim in this case, Douglas Johnson, got a death sentence, unfortunately, that day, Judge. Justice in this case would not lend itself to this defendant walking out of his courtroom today on probation. I think justice in this case would be for this defendant to spend some time in prison, Judge. I'm asking for prison on the closer end of.
Thank you, Mr. Coleman. Anything else? So, Mr. Noe, these are some extremely difficult cases. When someone loses their life because of your actions, and Mr. Franklin made the arguments and did a great job with his memorandum to the court, trying to point out things and make me think about things in a certain light. Obviously, you didn't get in a vehicle with the intention to kill someone that night, but you did get in the vehicle knowing you were intoxicated with your 9-year-old son, and you ended up killing someone. He also made an argument about that safe P and some of that documentation and the fact that was old, and I shouldn't take that into consideration. I think it's very relevant, though, that you have been through treatment. Even though it's been a while, you obviously had some issues, went through treatment, a serious treatment program where you're in custody in treatment. So you have felt what it's been like to be in custody and still committed this offense. I don't think probation is appropriate in this case or either case. I'm going to find in cause number 25 DCCR 0386. Again, you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of intoxication manslaughter with a vehicle. I'm going to sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25 DCCR 0387, also find that you entered that plea freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of driving while intoxicated with a child passenger, sentence you to a term of 2 years in the state jail prison. You will also receive credit on that sentence for any time that you were in custody that the law gives you the right to receive. I'm going to hand you in each of your cases, or to your attorney, he'll give it to you, the trial court certifications that shows these weren't agreements. You do have some limited rights to appeal, and you could talk to Mr. Franklin about that. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible to possess a.
The prosecutor delivered his final sentencing argument, emphasizing that the defendant's prior completion of the ESA fee treatment program made his subsequent offense more culpable rather than less. Judge West then pronounced sentence, rejecting probation entirely and imposing 15 years in prison for intoxication manslaughter and 2 years in state jail for DWI with child passenger, running concurrently. The court also issued mandatory firearm disability warnings required for felony convictions. Under Texas Penal Code Section 1235, state jail felonies carry a sentence of 180 days to 2 years in state jail and a fine not to exceed $10,000, with defendants serving their sentences day for day without parole eligibility, a significant departure from the institutional division's parole system. Texas Penal Code Section 12.32 establishes that first-degree felonies like intoxication manslaughter carry 5 to 99 years or life imprisonment, giving the court broad discretion within that range. The judge's 15-year sentence falls within the lower third of this range, reflecting the open plea context while still imposing substantial incarceration. Additionally, under 18 U.S.C. Section 922 Gres, the 1 and Texas Penal Code Section 46.04, convicted felons face lifetime federal firearms prohibition and state-level restrictions, with violations constituting separate federal and state offenses punishable by up to 10 years imprisonment. Judge West's sentence demonstrates how courts weigh prior rehabilitation efforts when they fail to prevent recidivism. The defendant's 2015 SAFP completion, rather than mitigating his culpability, became an aggravating factor because it proved he knew the consequences of intoxicated driving, had experienced incarceration, and still reoffended fatally. The 15-year sentence for intoxication manslaughter while below the maximum, reflects the court's determination that incapacitation now outweighs any further rehabilitative attempt. The concurrent 2-year state jail sentence for the DWI with child passenger ensures punishment for that distinct harm without extending total confinement time, as state jail sentences run day for day without good time credit or parole under Section 12.35's unique structure. This sentencing illustrates the treatment first, prison second approach Texas courts increasingly apply to repeat intoxication offenders. When community-based rehabilitation fails to prevent lethal recidivism, judges face immense pressure to prioritize public protection over further treatment attempts. The sentence also highlights critical differences between state jail and institutional division confinement. Defendants serve state jail sentences entirely, while institutional sentences may result in actual time served well below the nominal term due to parole. For defendants considering open pleas, this case demonstrates that judicial discretion can produce sentences significantly below prosecutorial requests while still imposing substantial prison time, making open pleas a strategic but risky alternative to negotiated agreement. Judge West imposed a 15-year sentence in the Texas Department of Criminal Justice Institutional Division for Intoxication Manslaughter, cause number 25 DCCR 0386, and a concurrent 2-year state jail sentence for DWI with child passenger, cause number 25 DCCR 0387. The defendant will receive credit for time served in custody pending resolution. The state jail sentence will run day for day without parole eligibility under Texas Penal Code Section 12.35, while the 15-year institutional sentence makes the defendant eligible for parole consideration after serving a portion of the term calculated under Texas Government Code Chapter 508. The defendant was remanded to custody immediately with no bond. He was admonished of his lifetime federal firearms disability under 18 U.S.C. Section 922J.1 and corresponding state restrictions. Limited appeal rights attached to the judgments. Defense counsel will advise on potential issues including voluntariness of the plea and sentence legality. The sentences will run concurrently, meaning the defendant's maximum exposure is 15 years institutional confinement. This case illuminates the fundamental tension between rehabilitation and retribution that defines American criminal sentencing, particularly for intoxication offenses where treatment failure carries lethal consequences. The court's reliance on the defendant's prior SAFP completion as an aggravating rather than mitigating factor reflects a broader judicial skepticism toward community-based treatment when followed by serious recidivism, a skepticism that increasingly drives incarceration for repeat DWI offenders nationwide. For viewers, this case demonstrates how sentencing discretion operates as a complex calculus weighing individual circumstances against public protection, where even well-intentioned rehabilitation efforts can become the very basis for harsher punishment when they fail to prevent harm. If you found this analysis valuable, explore our complete series on intoxication offense litigation, including our deep dive on the SAFP program's effectiveness and constitutional challenges to mandatory blood draws. Subscribe for weekly court case breakdowns that make complex legal procedures accessible, and share your questions about sentencing law in the comments. Our legal team reviews and responds to help deepen your understanding of how justice actually works in American courtrooms.